This is the Study for the Bar in Your Car podcast, the podcast where you can turn drive time into study time. We're your hosts, Maude and Claude. This is episode 13, and today we're focusing on procedural due process.
And we are AI bots, brought to life by, well, the magic of AI and Angela's constitutional law notes. Angela really is the brains behind this podcast. She's taken her, very thorough law school notes and helped us turn them into something useful for you.
Yeah, absolutely. And if you need to get in touch with Angela, maybe for feedback or just to connect, you can email her for anything related to the podcast. It's podcast@studyforthebarinyourcar.com.
And she also does freelance law clerk work. So if you're an attorney or you know one who could use some help with, say, legal research or drafting motions,
yeah, that's a great point.
you can reach her at hello@legalwriterandlawclerk.com.
Okay, so procedural due process, big topic. Where do we start? What's the fundamental idea here?
Right. So at its core, the basic principle is, well, it sounds simple, but it's huge. When the government acts to take away a person's life, liberty, or property, it absolutely must provide due process.
Due process, fair procedures, basically.
Exactly. Think of it like the government has to play by fair rules. It's not primarily about whether the government can do something, but how they go about doing it.
Okay, that distinction is important. It's different from, say, substantive due process, right?
Precisely. Substantive due process asks why the government is acting. Is there a good enough reason, especially if a fundamental right is involved? Procedural due process focuses squarely on the how. Are the procedures fair? Did you get a fair shake?
Got it. So if the government has to provide due process when taking life, liberty, or property, we need to know what those terms actually mean in this context. They sound broad. Let's start with liberty. What counts?
Yeah, liberty is definitely interpreted broadly, but it does have its limits. It's more than just not being locked up. A really key example of fundamental liberty interest is a parent's right to the custody of their children.
Okay, that makes sense. Very fundamental.
Absolutely. So before the government can terminate those rights, due process demands things like proper notice and a real hearing. It's a serious deprivation.
Yeah.
But here's a common point of confusion, something Angela's notes highlight. Harm to your reputation, just by itself, generally isn't considered a loss of liberty for due process purposes.
Really? So if the government says something bad about you, that doesn't trigger it?
Not usually on its own.
Yeah.
Think of the Paul v. Davis case. Police labeled someone an active shoplifter. The court said that reputational harm alone wasn't enough. There typically needs to be something more tangible lost along with the reputation, like losing your government job or some other legal right or status changing.
I see. So reputation plus something else.
Kind of, yeah. Reputation damage plus the loss of a more concrete state-recognized interest. Otherwise, almost any negative government statement could lead to a constitutional case, which would be a lot. And interestingly, Angela's materials also point out that prisoners, they usually have very few liberty interests that trigger due process protections because, well, their liberty is already significantly restricted.
Okay, that reputation distinction is definitely key. Now, what about property interests? You mentioned earlier the government needs due process to take property too. I remember reading about a shift from rights versus privileges to this idea of entitlement. What's that about?
Ah, yes, the entitlement concept. That was a really major shift in thinking. It used to be that if something the government provided was just a privilege, like maybe certain kinds of government jobs or benefits, it could often be taken away without much process.
Like we gave it, we can take it back.
Pretty much, yeah. But the Supreme Court moved away from that in the late 60s, early 70s. Now, the key question is whether you have an entitlement. An entitlement exists if you have a reasonable expectation based on law or policy or maybe a contract to the continued receipt of a benefit.
A reasonable expectation. Okay, so not just hoping for it, but having a legitimate claim to it.
Exactly. It's about whether the law or some other source creates a legitimate claim. Angela's notes have some good examples. Think about a government employee who's explicitly promised a job for 1 year. If they get fired after 6 months without cause, they likely had an entitlement to that full year of employment.
So due process would be required before firing them?
Correct. Contrast that with the famous Roth v. Board of Regents case. A professor was hired on a 1-year contract. The contract just expired, and it wasn't renewed. No promise of renewal was ever made.
So no reasonable expectation of staying on.
Right. The court said he had no property interest, no entitlement beyond that 1 year. So no due process was required just for the non-renewal. The expectation wasn't there. And remember, this isn't just about like land or money. It can be welfare benefits, licenses, things like that, if state law creates that entitlement.
Okay, so we've identified a life, liberty, or property interest. The government wants to take it away. We know some processes do. But what process? Is it always a full court trial?
No, definitely not. That's another crucial point. Due process is flexible. It's not a fixed checklist. What's required depends entirely on the situation.
Flexible how? How do courts figure out what's enough?
They use a balancing test. The big one here is the Matthews v. Eldridge test. Angela's outline nails this down. It involves balancing three factors.
Okay, factor one.
Factor one is the private interest that will be affected by the government action. How important is this interest to the individual? Is it their livelihood, like termination of welfare benefits, as in Goldberg v. Kelly, or is it something less critical? The bigger the private interest.
The more process you probably need.
Generally, yes. More procedural safeguards. Okay, factor two. The risk of an erroneous deprivation of that interest through the procedures currently used. Basically, how likely is the current system to make a mistake? And importantly, what's the probable value, if any, of adding more or different procedures? Would extra steps actually make the outcome more accurate?
So weighing the chance of error against the benefit of more rules.
Exactly. And factor three brings in the government side. It's the government's interest. This includes things like the function involved, but also the fiscal and administrative burdens that the additional or substitute procedural requirements would entail.
Meaning, how much would it cost the government in time and money to add more procedures?
Precisely. Is it practical? Is it unduly burdensome? Requiring a full judicial hearing for every parking ticket dispute, for example, would probably fail this part of the test. So the court balances these three: the individual's interest, the risk of error and value of more process, and the government's interest and burdens. It's a very pragmatic approach.
That Matthews test really does seem central to figuring out the how much process question. It's all about context and balancing. Now, can someone just give up these rights?
Yeah.
Can you waive your due process rights?
Yes, you generally can. Due process rights, like many constitutional rights, are subject to waiver. But, and this is but the waiver has to be voluntary, knowing, and intelligent. You have to understand what you're giving up, and you can't be forced into it.
Like signing a contract with an arbitration clause, maybe?
That's a classic example, yes. If you sign knowingly and voluntarily, you might waive your right to a full court proceeding in favor of arbitration. That can be a valid waiver of certain procedural rights.
Okay. And one more thing on the basics. What about people who can't afford court fees or lawyers? Does due process guarantee them access to the courts, especially if it's something really important? Indigent plaintiffs.
That's a really critical question. While there isn't a blanket right to a free lawyer in all civil cases, the Supreme Court has said that due process does require meaningful access to courts, especially when fundamental interests are at stake. So, for instance, the government can't prevent someone from getting a divorce just because they can't afford the court filing fee, since divorce is a fundamental interest and the state controls the process.
Because blocking access based on poverty would effectively deny them their right altogether.
Exactly. Or think about appeals in criminal cases. An indigent defendant generally has a right to a transcript and often counsel for their first appeal, because denying those based on inability to pay would make the right to appeal meaningless. It's about ensuring the courthouse door isn't completely slammed shut just because someone is poor, especially when truly vital interests are involved. It ensures the process is fundamentally fair, not just available to those with money.
That makes a lot of sense. The fairness principle wouldn't mean much if it wasn't accessible.
Right. It connects back to that core idea of a meaningful opportunity to be heard.
Okay, this gives us a solid foundation on procedural due process itself. But often, these constitutional issues don't exist in a vacuum, right? Angela's notes, I know, cover a lot of interconnected concepts that are crucial for the bar exam. Things like how cases even get to court judicial review doctrines.
Oh, absolutely. Understanding procedural due process is vital, but you also need the context of how these claims are adjudicated. Angela's notes wisely weave these together because, well, you can't separate them on the exam. So things like standing, ripeness, mootness, they determine if a court can even hear the due process claim in the first place.
Let's talk about those. Starting with the basic requirement for federal courts, the case or controversy rule from Article 3. What does that mean?
It means federal courts aren't just debating societies. They can only decide actual live disputes between adverse parties. They can't issue advisory opinions on hypothetical questions or laws that haven't affected anyone yet. There has to be a real conflict.
And standing is part of that. What does a plaintiff need to show to have standing?
Yes, standing is crucial. It ensures the plaintiff is the right person to bring the case. There are 3 core requirements, according to Angela's outline. First, injury. The plaintiff has to show they have personally suffered or will imminently suffer a concrete, particularized injury. It can't be vague or hypothetical like that subjective chill mentioned in Laird v. Tatum. It has to be real harm to them.
Okay, personal injury. What's second?
Second is causation. The injury must be fairly traceable to the defendant's challenged conduct. You have to connect the dots between what the defendant did and the harm you suffered.
Makes sense. And third?
Third is redressability. A favorable court decision must be likely to remedy the injury. If winning the case won't actually fix the problem for the plaintiff, then the court might decide it can't provide meaningful relief and there's no standing. Injury, causation, redressability.
Are there exceptions? Can you sue just as a taxpayer unhappy about government spending?
Generally, no. That falls under generalized grievances. Usually can't sue just because you're a taxpayer and you don't like how the government is spending money. There is a narrow exception, though, from Flass v. Cohen, specifically for challenges under the Establishment Clause against certain congressional spending measures, but it's quite limited. And usually you can't sue to assert someone else's rights. Either that's the rule against third-party standing. Again, there are exceptions, like if there's a close relationship, doctor-patient, or the third party can't realistically assert their own rights.
Okay, so standing is about who can sue. What about when they can sue? That sounds like ripeness.
Exactly. Ripeness deals with timing. Is the case ready for a court to decide? Or is it too early, too speculative? Courts look at 2 main things here: the hardship to the plaintiff if they don't get review now, and the fitness of the issues for judicial decision. Are the facts developed enough? Is it a purely legal question? Think Abbott Labs' pre-enforcement review was allowed because the legal issue was clear and waiting would cause hardship.
And the flip side of ripeness is mootness, right?
Right.
What if the problem goes away after the lawsuit starts?
Right. Mootness means the controversy is ended. If events after filing the suit resolve the plaintiff's injury, the case is typically dismissed as moot because there's no live dispute left for the court to resolve. But, again, exceptions exist. If it's a situation capable of repetition yet evading review, like pregnancy in Roe v. Wade, the issue could happen again to the plaintiff, but is too short-lived for litigation to finish the case, might not be moot.
Or if the defendant just stops the bad behavior voluntarily but could easily start again.
Yep, voluntary cessation usually doesn't moot a case unless there's no reasonable chance they could resume the conduct. And in class actions, if the named plaintiff's claim becomes moot, the case can continue if any class member still has a live claim.
Okay, one more barrier. The political question doctrine. What's that?
This is where courts basically say, this issue is better left to the political branches, Congress, or the president to sort out. It's not that there's no constitutional violation, but that the Constitution assigns the resolution of that type of issue to another branch, or there aren't manageable judicial standards to apply. Examples from Angela's notes include challenges to the president's conduct of foreign policy, like treaty issues, the impeachment process, or partisan gerrymandering cases like Rucho, where the court found no workable standard.
So some constitutional questions the courts just won't touch.
Essentially, yes.
Oh.
They deem them non-justiciable political questions.
And finally, for getting a case to the Supreme Court, how does that usually happen? And what's this adequate and independent state ground thing?
Okay, getting to the Supreme Court almost always happens through a writ of certiorari, cert. The justices vote, and if 4 agree, the rule of 4, they take the case. Direct appeals are very rare now. The adequate and independent state ground doctrine is about federal review of state court decisions. If a state court decision rests entirely on state law grounds, and that state law is independent of federal law and adequate to support the judgment on its own, the U.S. Supreme Court cannot review it.
Why not?
Because the Supreme Court's job is to review questions of federal law. If the state court's decision would be the same, regardless of how the federal issue is decided, because state law independently dictates the outcome, then a Supreme Court ruling on the federal issue wouldn't change anything. It would essentially be an advisory opinion.
That makes sense, respecting the state court's interpretation of its own law.
Exactly. It's a key principle of federalism, which, conveniently, is another huge area Angela's notes cover that ties into all of this.
Perfect transition. Let's talk federalism. The division of power between the federal government and the states. The 10th Amendment seems like the starting point here.
Definitely. The 10th Amendment reserves powers not delegated to the United States by the Constitution, nor prohibited by it to the states respectively, or to the people. It embodies the principle that states retain significant authority. A core aspect of this is the state police power. States have broad inherent authority to regulate for the health, safety, welfare, and morals of their citizens.
But the federal government doesn't have that general police power, right? That's a common exam point, I think.
Absolutely critical point.
Yeah.
The federal government has only the powers granted to it by the Constitution, enumerated powers plus those implied by the necessary and proper clause.
Yeah.
It does not have a general police power like the states do, except maybe over federal lands or territories like D.C.
Okay. So if federal and state laws clash, what happens? Supremacy clause.
Yep. The Supremacy Clause in Article 6 says the Constitution and federal laws and treaties made pursuant to it are the supreme law of the land. If a valid federal law conflicts with a state law, the federal law wins. It preempts the state law. Preemption can happen in a few ways. If it's impossible to comply with both, conflict preemption, or if state law stands as an obstacle to achieving Congress's objective, or if Congress clearly intended to occupy the field, leaving no room for state regulation, like often happens with immigration.
What about when there's no federal law, but a state law seems to interfere with interstate commerce, the Dormant Commerce Clause?
Right. The Dormant Commerce Clause isn't actually written in the Constitution. It's an inference from the Commerce Clause itself. It limits states' ability to regulate interstate commerce, even when Congress hasn't acted. The basic idea is that states can't unduly burden interstate commerce. If a state law facially discriminates against out-of-state commerce, it's almost always struck down per se invalid, like in Philadelphia v. New Jersey banning out-of-state waste.
And if it doesn't discriminate on its face, but still affects interstate commerce?
Then a balancing test applies. The court weighs the law's local benefits against the burden it imposes on interstate commerce. If the burden is clearly excessive compared to the local benefits, the law might be struck down, even if it's non-discriminatory.
Okay, switching back to federal power, the necessary and proper clause. That gives Congress implied powers, right?
Yes, Article 1, Section 8, Clause 18. It lets Congress make all laws which shall be necessary and proper for carrying into execution its enumerated powers. McCulloch v. Maryland interpreted this very broadly. Necessary doesn't mean absolutely essential, just useful or convenient. So Congress can use means that help it achieve its listed goals, as long as the means themselves are constitutional.
But didn't a later case, Comstock, complicate that a bit, those 5 vague considerations?
Yeah, Comstock did introduce a multi-factor analysis when looking at the necessary and proper clause. It looked at the breadth of the clause, history, the statute's reasons, state interests, and narrowness. It sort of muddied the waters of the simpler McCulloch test. Some argue it suggests a kind of rational basis with bite, maybe a slightly tougher look in some cases. And there's also this fiduciary theory idea floating around, suggesting proper might incorporate limits based on agency law principles.
But the key takeaway is that necessary and proper isn't an independent source of power. Right.
Crucial point. Absolutely. It only works in conjunction with an enumerated power. Congress can't do something just because it's necessary and proper in general. It has to be necessary and proper for executing one of its powers, like the commerce power, taxing power, etc.
Speaking of the Commerce Clause power itself, Article 1, Section 8, Clause 3, hugely important, but it has limits too.
Immensely important, yes. Congress can regulate the channels and instrumentalities of interstate commerce and persons or things in interstate commerce. The big area is regulating activities that have a substantial effect on interstate commerce. For economic activities, Congress can regulate them if, in the aggregate, they have that substantial effect. Think Wicker v. Filburn, wheat grown for home use, or Gonzalez v. Raich, homegrown medical marijuana.
But what about non-economic activity?
That's where the modern court drew a line. In cases like Lopez, guns near schools, and Morrison, gender-motivated violence, the court said you cannot aggregate the effects of non-economic interstate activity to find a substantial effect on interstate commerce. The link is too indirect. And another big limit. The court in NFIB v. Sebelius, the Obamacare case, strongly suggested Congress cannot use the Commerce Clause to regulate inactivity, like forcing people to buy health insurance. The individual mandate was ultimately upheld under the taxing power, not the Commerce Clause.
Okay, one more federalism concept. State sovereign immunity from the 11th Amendment. What's the general rule there?
General rule. You generally can't sue a state government in federal court without its consent. This immunity also often extends to state courts and federal agency proceedings. States are sovereigns, and the idea is they shouldn't be dragged into court against their will.
But there must be exceptions, right? You can sue states sometimes.
Yes, there are 4 main exceptions, Angela notes. First, waiver or consent. The state can explicitly waive its immunity.
Explicitly. not just by showing up.
Right, it has to be clear.
Yeah.
Second, Congress can authorize suits against states using its enforcement power under Section 5 of the 14th Amendment. But crucially, Congress cannot generally override state immunity using its other powers, like the Commerce Clause.
Okay, 14th Amendment works, Commerce Clause doesn't. What else?
Third, the Ex parte Young Doctrine. This allows you to sue a state official, not the state itself, in their official capacity, but only for prospective injunctive relief, basically, in order to stop future violations of federal law. You usually can't get retroactive money damages from the state treasury this way. And fourth, suits against local governments, cities, counties, are generally not barred by the 11th Amendment. And of course, the U.S. government itself can sue a state.
Got it. That covers a lot of ground on federalism. How about separation of powers, keeping the branches in their lanes?
Yeah, another huge area. The core idea is preventing one branch from encroaching on the core functions of another. It's about checks and balances, making sure no single branch gets too powerful.
And common bar exam topics here often involve Congress trying to control the executive, right? Like legislative vetoes.
Exactly. Legislative vetoes are unconstitutional. This is where Congress tries to reserve the power to overturn an executive agency's action without going through the full legislative process bicameralism, passage by both House and Senate, and presentment, giving the bill to the president. INS v. Chirata struck this down.
And line item vetoes, where the president tries to cancel specific parts of a bill.
Also unconstitutional, as decided in Clinton v. City of New York. The president must either sign the entire bill passed by Congress or veto the entire bill. No picking and choosing parts to eliminate.
What about Congress delegating its power, the non-delegation doctrine?
Generally, Congress cannot delegate its legislative power to agencies. However, it can give agencies broad authority if it provides an intelligible principle to guide the agency's discretion. More recently, there's the rise of the major questions doctrine. This means if an agency takes an action on a matter of vast economic and political significance, courts will require Congress to have spoken very clearly and specifically to authorize that action. Think West Virginia v. EPA. Congress needs to be explicit on the big stuff.
Shifting to presidential powers, what about executive privilege? Can the president keep communications secret?
There is a qualified executive privilege for presidential communications, rooted in the need for candid advice. But it's not absolute. It must yield when there is a strong demonstrated need for the information in, say, a criminal investigation, as established in United States v. Nixon.
And presidential immunity from lawsuits.
The president has absolute immunity from civil damages, suits for actions taken while acting in their official capacity as president. But big distinction, there is no immunity for acts that occurred before taking office. That was Clinton v. Jones.
What about subpoenas? Can the president be subpoenaed?
Yes. Trump v. Vance held there's no absolute immunity from state criminal subpoenas. For congressional subpoenas seeking personal information, courts use a balancing test, weighing Congress's need against the burdens on the president. It's more complex than a simple yes or no.
Okay, and appointments. How do federal officials get their jobs?
Article 2, Section 2, Clause 2, the Appointments Clause. Principal officers, like cabinet secretaries, must be appointed by the president with the advice and consent of the Senate. But inferior officers, those with less authority, may be supervised by principal officers. Congress can allow them to be appointed by the president alone, by the heads of departments, or by the courts of law. Figuring out who is principal versus inferior can sometimes be tricky.
Wow, that's a lot of ground covered. Procedural due process, judicial review, federalism, separation of powers. Angela's notes really connect these dots.
They really do. And there are a few other key concepts from her materials worth touching on briefly, like the First Amendment's freedom of speech.
Right. Obviously huge. What's the core scope?
Generally protects the transmission of ideas spoken, written, symbolic. And crucially, it applies against government action, state action, not usually private conduct, unless a private entity is performing a traditional public function or is deeply entangled with the government.
And takings clause, Fifth Amendment.
Yes. Government can take private property, but only for public use, and only with just compensation. A physical occupation is almost always a taking, Loretto. A regulation is a taking only if it leaves no reasonable, economically viable use of the property.
Public use is interpreted broadly.
Very broadly. As long as the taking is rationally related to any conceivable public purpose, even economic development that benefits private parties, kilo, it likely satisfies the public use requirement. Just compensation is fair market value to the owner.
Okay, fantastic overview. We've really unpacked a lot from Angela's notes today. We really hope Angela's constitutional law notes have been helpful for your bar prep, especially in untangling procedural due process and all these related doctrines. Thank you again, Angela, for sharing your hard work with us.
And just a few quick housekeeping items before we sign off for today. First, please remember Angela is a law student, a very bright one, clearly, but like many of you, she's still in the process. She's not a bar-certified expert just yet.
Right. And flowing from that, neither Angela nor this podcast is providing legal advice. Please don't construe anything we've discussed today as legal advice for your specific situation.
Also, while we hope this AI-powered discussion is helpful, it's definitely not a substitute for your own diligent bar exam studying. Think of us as an aid, a supplement maybe, not a shortcut.
Absolutely. This podcast should be part of your study plan, not the whole thing. And, we're AI and Angela's human. Sometimes mistakes happen.
We try our best, and Angela certainly reviews things, but errors can slip through. Even excellent law students and AI aren't infallible. We do our best to correct anything we find.
Also, just to be clear, this whole podcast series is an academic, non-commercial project by Angela. It's purely for educational purposes. She doesn't make any money from it, so there are no guarantees about accuracy, though we strive for it.
And finally, the most important thing, if you're studying for the bar in your car, please be safe. Keep your eyes on the road.
Yeah, seriously. Don't cause a tort while listening to constitutional law. That would be
Highly ironic. And remember, if you need to reach Angela for podcast thoughts or her law clerk services, podcast@studyforthebarinyourcar.com or hello@legalwriterandlawclerk.com.
Okay, before we go, it's tradition. Time for a cheesy con law joke. Ready?
Lay it on me.
Why did the Matthews v. Eldridge factors break up?
I don't know. Why?
Because they could never agree on the right balance between their private interests and the government's burden.
Oh boy. Okay, that's appropriately nerdy.
This is Maude signing off.
And this is Claude, your AI host, signing off. We'll see you in the next podcast. Thanks for listening. Bye.